Okay, hi again. Attorney Steve Vondran here, licensed practice law in California and Arizona. We are talking in this series about malicious prosecution. What is it? Now, you may hear this a lot of times. You may be involved in a lawsuit and somebody's suing you for no reason at all. In fact, I'm dealing with such a case right now, which is why I decided to do this video. I was actually looking into the law on malicious prosecution because I may have to come back and sue the party that's suing my client for malicious prosecution. So I decided to give you guys a little primer on this. Also, some people confuse the difference between malicious prosecution and abusive process. So I'm going to touch on that really shortly, okay? So really simple, malicious prosecution, I have the definition up here. This is what needs to be shown to a jury, if I can get this down here. So there we go. Okay, so malicious prosecution, also known as the wrongful use of civil proceedings. Okay, to establish a claim for malicious prosecution, the plaintiff has the burden of proof. If you don't know what a burden of proof is, Google Attorney Steve, burden of proof. I got a video out there for you, okay? To establish malicious prosecution, the plaintiff must prove all of the following. One, that the defendant was actively involved in bringing or continuing a lawsuit, okay? So essentially the crux of this tort is that a plaintiff is suing you for no reason or suing you for various causes of action that have nothing to do with the case, simply designed to harass you and force you into settlement, and doing it with ill will and bad faith, okay? So number one, you must prove there was a lawsuit. Two, that the lawsuit ended in the plaintiff's favor. So this is one that catches some people sometimes. They think that you can just file a countersuit when you're being sued. So in other words, somebody sues you for negligence and you go, that's totally crazy, I didn't do anything, I'm going to sue you back for malicious prosecution. You can't do that. You have to wait till the end of the case. You have to wait till the litigation was terminated in your favor, okay? And I haven't read here that the trial judge decides. This is something that the trial judge is going to decide if you decide you're going to file a malicious prosecution case. This is something that is going to be a question for the judge. So the judge may look at it and say, well, the case was dismissed. The plaintiff in your other court case, they dismissed it. So, I'm not gonna conclude that that's a decision on the merits. But the judge could also go the other way and say, well, wait a second, you dismissed it because you knew it was junk. The defendant pointed it out to you. You knew it was a worthless claim, and you brought it anyway. And that's what I'm dealing with right now. I put the other party on notice that you're filing a cause of action that has absolutely nothing to do with the proceedings that we're involved in. So it's just designed to harass. So I put them on notice, is saying you're filing this for an improper purpose, and assuming that we terminate this in our favor, like win on a demur, or if you decide to voluntarily dismiss it, we may be pursuing a malicious prosecution claim afterwards. Okay, so now this is where the settlement comes in. Maybe you end up settling and it doesn't really matter, and you release all your claims. But nonetheless, let's continue to go through here. So the lawsuit must have ended in the plaintiff's favor. Judge is going to decide that. Number three, no reasonable person in defendant's shoes would have believed there were reasonable grounds. This again is a judge standard. It's an objective standard. The judge is going to look and ask the question basically, would any reasonable person have brought this claim? Let me see. If the answer is no, then you might be able to meet element number three. Element number four. Now you have to prove all these things as a plaintiff, not just one or two. You got to prove them all. That's the way it goes. Number four, that defendant, this is another big one, that defendant acted primarily for a purpose other than succeeding on the merits of the claim. And again, I put here with malice. Okay, so this is where the defendant's subjective state of mind, subjective, where you may examine what was the attorney thinking, what did he know, what facts were available to him. Was it his client telling him something? Was he relying on bad case law? What exactly was it? And was this filed actually for a proper purpose? Now, the case I'm dealing with now, the plaintiff had already had their filing a cause of action for, what were they filing a cause of action for? I forget. But anyway, too many cases in my head. But they were filing a certain action, and basically it had been dismissed on demur. Now they're bringing it again against a couple new clients. So to me, they're just raising new claims, bringing in new parties, And at some point, to me, there's no grounds to do this. So that's where you're going to look and see, did the defendant act for an improper purpose or something other than trying to succeed on the claim? Now, some subjective states of mind that could get you here: hostility, ill will, indifference, or just simply suing people to try to force a settlement. I've had different defendants thrown on there. Why are you suing this person? They had nothing to do with it. Well, sorry, nothing was happening in the case. You know what I mean? So these are the kinds of things that they're going to look for and try to decide if you can meet them. Number 5, plaintiff must be harmed. There must be some out-of-pocket damages, some mental suffering, those kinds of things. 6, defendant's conduct was a substantial factor in causing the harm. So in all your torts, you have the element of causation. Okay, so there's your 6 elements to make what we call a prima facie case. If you know that word, you're ahead of your friends. A prima facie case, you need to plead and prove those 6 elements to have a prima facie case. Well, there's potential call now. Hold my call, sir. We'll let that go in the background here. Here's a couple special notes on malicious prosecution. Oh, I know what I was going to say. They were adding a conversion cause of action that just made absolutely no sense. So, it's one of those things. So anyway, let's go through some of these notes here real quick. Note, there is no special litigation privilege for an attorney who files in bad faith. Now, when you're in litigation as an attorney, I have, believe it or not, a privilege to defame or say what I want or pursue what I want, but that litigation privilege does not apply if someone's bringing a malicious prosecution claim. So an attorney cannot rely on, hey, I thought I could just do whatever I want. I'm an attorney. I'm a big shot. It doesn't work that way. Note 2 can apply to one cause of action, as we talked about, the conversion claim that's being brought. Makes absolutely no sense. It's already lost once on demurrer. He's trying to bring it again. I mean, it's just, it's just nonsensical. It's like, what's going through your mind? So it can apply to one cause of action, does not need to be the whole complaint. Another note, probably does not apply to less formal proceedings where you're not having these full adjudications on the merits, like a small claims court case. I've got a great video out there for small claims, but if you lose, let's put it this way, somebody files a bogus small claims court case, you might not be able to get there. Check your case law. These are just general legal information only. This is not legal advice. Do not rely on this video. I'm just giving you some general tips here and some things to look into. Okay, so you may find some case law that says, sure, you can. Maybe there's a case, coming out of San Francisco where you're allowed to do that. You never know. So look up your case law. Again, needs a lack of merit. 2 more notes. Needs a lack of merit. A voluntary dismissal, as I mentioned, could apply if it was brought because they knew there was nothing to it. But if the dismissal was due to a motion to dismiss, lack of jurisdiction, statute of limitations, something like that, might not constitute a favorable termination on the merits. So that's the magic buzzwords. You're looking for a favorable termination for the plaintiff. And so that's a factual issue. Okay, finally, a litigant can lack probable cause for his action either if he relies upon facts which he has no reasonable cause to be true. In other words, well, I thought it was this, but, the facts are just, kind of, fake facts, let's call them. You were just making things up, just for the heck of it. Or if he seeks recovery upon a legal theory which is untenable under the facts known to him, and that's what I'm talking about with this conversion claim. Makes no sense, so I might be needing to bring something like this. Again, here's your different levels of damages here. You got your attorney fees that you had to spend to defend yourself. You got your costs of the new suit, the cost of service, and the summons of the service of the summons and complaint. You have emotional distress. All kinds of different emotional distress may qualify. Injury to your reputation. Now you have a public court record. Somebody may have been accusing you of fraud, something you had nothing to do with. Now in your background checks for your employment, looks like you've been convicted of fraud or you ended up dealing with a fraud case. There's a lot of different things, but you have lost earnings, lost profits, medical expenses, those kinds of things. All right. Now let's get down to abuse of process, and I'm just going to tell you these 2 torts are not the same. Malicious prosecution and abuse of process are not the same, so don't mix them in and call it all the same thing. The abuse of process is an abuse of a judicial litigation tool that litigants have. For example, I have the power when I file a lawsuit, I have the power to take a deposition of this person or that person. But if I'm taking depositions of somebody just to harass, maybe I'm calling somebody's grandma in just to harass her, just to, oh, she's 95 years old, this is gonna really upset everybody. That's more along the lines of abusive process. You're misusing one of the litigation tools given to litigants, and it causes harm. And again, that's a separate cause of action. So in a particular case where you have a runaway plaintiff that's going crazy, you could win your case. You could come back and sue for malicious prosecution. You could also sue for abuse of process. So that's how it works. That's the difference. If you know that, you know more than 99% of people ever will. As we like to say, be smarter than your friends. Okay, so there's my information. If you need more information, we're intellectual property, business, real estate, litigation firm. If you need some help, there's our information. We hope you've enjoyed this video. If you have, feel free to share it on your social media networks. Leave some comments down below, comments or questions. Don't forget to give us a like. That's always helping us out. And if you really want more of these videos and you really want to be smarter than your friends, what do? You subscribe. There we go. All right, Attorney Steve Vondran, I got to get back to work. Have a great day. We'll talk again.